Hello, everyone. My name is Brian Zickafus. I'm a labor and employment attorney in the Kansas City office, and I'm going to be your moderator for today. We're back this fall with our virtual seminar series, and we'd like to welcome our attendees from Illinois, Kansas, Missouri, or wherever you may be. We've got a lot to cover, and I want to get right to it, but we have a couple of housekeeping items that I need to cover. At the bottom of your audience console, there are multiple application icons for your use during the program today. If you have any questions during the webcast, submit them via the question box. We'll try to answer all the questions during the webcast today, but if a fuller answer is needed or we run out of time, it will be answered later via email. We have a whole host of folks next door trying to respond to questions, but due to volume or complexity, it may take a little bit more time, so bear with us. A PDF of the presentation and other resources are available in the resources folder. This program has been approved for HR and CLE credit. To report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow along with a recording of the webcast for watching and sharing. Toward the end of the program, be sure to complete our short survey. We value your feedback and want to make sure we are ultimately giving you what you want. That's all for the housekeeping items, so let's get started with our program. We have 3 sections of content. Each section will be about 30 to 35 minutes in length. We'll have short breaks in between, but we will have some poll questions that we think you should stick around for. To be candid, some of these are business related and some of them are not. So first up, Jillian Moles, Blake Armstrong, and I will kick off our program with a legal update on recent changes in the past 6 months in Illinois, Missouri, and Kansas. Jillian is a labor and employment attorney in our Chicago office, but she's here with me today in Kansas City presenting. And Blake is an attorney in our St. Louis office, and he is presenting from the St. Louis office today. Jillian, take it away.
Thanks, Brian. As he noted, I am a labor and employment attorney in the Chicago office in Illinois, and I'm going to kick it off with some updates in the Illinois labor and employment space, which is always a very active area. And we're going to cover 4 main topics today. 2 of them have to do with changes in terms of hiring and what employers can do, bringing on employees, what records we can use, what agreements we can have them sign in terms of conviction records and restrictive covenants. The other 2 are expanded leave for employees. So these have to do with the Employee Sick Leave Act and VASA, and they're giving employees some more availability for leave, for reasons, and for covered family members. So we're going to start with an amendment to the Illinois Human Rights Act, which is aptly named the Employee Background Fairness Act. This actually became in effect in March 2021. And so this restricts employers from relying on an applicant's or an employee's conviction records to make any adverse employment decisions. And there are 2 exceptions to this. And you'll see that one is if there's a substantial relationship between the conviction and the employment action at issue. And the other exception is if hiring or continuing to employ the individual will create an unreasonable risk to property or safety of others. But it's not as easy as, an employer relying on those 2 exceptions. The statute requires that employers provide notice. They provide the applicant an opportunity to respond, and it also lists some certain mitigating factors that employers need to consider. And so first, let's take a look at how Illinois defines conviction record, which is a little bit broad because it talks about any information indicating a conviction, and it also includes probation, fines, imprisonment, or paroles, and that's pursuant to any law enforcement or military authority. So it's a broad definition, especially because it refers to any information. The statute also lists factors that must be considered, and these are ones that must be considered, but of course they allow for others. So employers need to consider what the length of time is since the conviction at issue, the number of convictions the employer applicant has, the nature and severity of the conviction, any related facts and circumstances, how old the employer applicant was when this happened, and any rehabilitation efforts that have happened since then. And even so, when considering all those factors, the employer cannot just then enforce one of those exceptions. They have to engage in what we all know and love called an interactive process. And they need to do this with the applicant or the employee by notifying the employee in writing of their intent to rely on the conviction to make this adverse employment decision. And they need to include a copy of the conviction report. Then they need to provide the employer applicant 5 days to respond. And the employer also needs to notify the employee or applicant of the reasoning. And after the employee has 5 days to respond to try and change the mind of the employer and give a reason as to why it should not be used as an adverse employment decision, then the employer can go ahead and take that action. So there's definitely a lot of steps to consider, and it's something that employers need to take into account when using conviction records. And just a note, this is in addition to Illinois' ban the box statute. That focuses on when an employer can get a conviction record, and this is now defining how employers can actually use that record. And so that statute is in effect already as of March 2021. The next amendment we have is amendments to Illinois' Employee Sick Leave Act. And this is also already in effect as of April 2021. And just a background to do a refresher on the Employee Sick Leave Act, it's fairly new. It was instituted in 2017 to give employees the ability to take some of the sick leave benefits that employers already grant them for care related to covered family members. So that definition does stay the same in these amendments, and that includes children, stepchildren, domestic partners, a whole host of any family relations. But the real change here is that the amendments allow employees to take leave for personal care. And again, it's another very broad definition. And this expands it to medical appointments, hygiene, nutritional, safety needs. And you can realize that a lot of different scenarios come under those factors. It allows for the employee to provide transportation to any kind of appointments. And one real a new provision of this is that it also covers just being physically present to provide emotional support to a family member with a serious health condition. And that's when they're receiving inpatient or home care. And that's for any of those covered family members. And I think we can all realize that this is something that has come as a result of COVID. A lot of employees have needed to take time off. They've needed to do all kinds of different care for family members. And this is Illinois' way of kind of codifying that in the statute. And now we're going to get to some of the changes that relate to hiring. And this is a big kicker in Illinois, and this becomes effective in January of 2022. So as of January 1st, 2022, any covenants not to compete, any covenants not to solicit are covered by these new amendments to Illinois' Freedom to Work Act. And there are some big restrictions here. So previously, employers could enter into non-competes and only if the employee was paid a certain amount of money, and that threshold was very low. And now Illinois has increased that to $75,000, which is a drastic change from where it started out. So now employers are not permitted to enter into non-competes with employees who earn $75,000 per year or less. And that amount is going to increase starting in 2027. So that $75,000 will increase as the years go on. Another change is that the prior restrictive covenant law did not specifically mention non-solicit agreements. And so now it does specifically include non-solicit agreements, and it lowers that threshold to $45,000. So employers cannot enter a non-solicit agreement with any employers who earn $45,000 or less. The statute also now specifically requires employers to advise the employees that they have the right to and should consult with an attorney before signing the agreement, and employees are now given 14 days to consider the agreement. So there's a lot of changes there. And a few more are, a lot of times employers rely on at-will employment as adequate consideration at the time of signing for these restrictive covenants. That is only going to be adequate in Illinois as of January 1st, 2022. if that at-will employment lasts for 2 years after the signing of the agreement. So even if the employee has been an employee, the person has been an employee for a specific amount of time, it's 2 years from the signing of the agreement that at-will employment will be considered adequate consideration. Otherwise, the employer will have to provide professional or financial benefits that are adequate by themselves, such as a bonus or some other kind of financial incentive. This law also specifically references COVID-19 or similar circumstances, and I think this is probably Illinois' way of kind of encompassing any similar situations that may come up in the future that we can't really predict right now. And what it does is it voids restrictive covenants for any employees who are furloughed or terminated due to circumstances related to COVID-19. And employers, there is an exception. Employers can enforce these agreements only if they pay the employee the base salary, which from the time of their termination through any time they get subsequent employment. So really they have to keep the employee on the payroll to enforce these restrictive covenants until the employee gets new employment. And that's the only way that they can enforce that against these employees who are furloughed or terminated due to COVID-19. And another big portion of these amendments are that it allows employees to recover their attorney's fees and costs for defeating a restrictive covenant action. So that's really something to keep in mind for any of these future actions. And the last update we're going to talk about is Illinois' VASA statute. This applies to all Illinois employers. And again, it's another expanded type of leave that Illinois provides. And this is for employees who are victims of domestic or sexual violence, or who have family or household members who are victims of such violence. It allows the for employers with a certain amount of a threshold to take 12 weeks of unpaid leave for any 12-month period. And it includes, again, a lot of different scenarios. So it allows the employee to take leave to seek medical help or get legal assistance or counseling, safety planning, whatever they need to take care of that comes as a result of the domestic or sexual violence. And employers, of course, employees do have to provide documentation to substantiate their leave under the statute, but it's a little broad because they can include court records or documents from their attorneys or clergy or medical professionals, anything to kind of substantiate the reason that they want to take this protected leave. And the amendments here again expand the protections for employees. This is one of the laws that becomes effective January 2022. It adds crimes of violence, and employees are now allowed to take leave for crimes of violence. And the actual statute references the Illinois Penal Code and certain sections of the Illinois Penal Code. So what those sections cover are things like homicide, other sex offenses, bodily harm, harassing or obscene communications, terrorism, or armed violence. So that really expands the different types of scenarios that employees can take leave under the statute for, because it's not just sexual or domestic violence. It encompasses a whole new group, kind of under the same umbrella, though, as you can see. And it also, again, expands the definition of family or household member. And the real point here is that it includes any other individual whose close association to the employee is the equivalent of a family relationship. And that's as determined by the employee. So it's not the employer's decision to decide, this is not your family or household member. It's as determined by the employee. And again, I think that has come up as a result of family situations in COVID and, dealing with all those things. So really the employee can define if they want to take leave to help one of their family or household members under this statute. And a couple more changes are that the documentation we talked about, the employee now only has to provide that if they possess it already. So it's not they only have to provide it to the employer if it's something that they already have in their possession. It can't be something that the employer, it makes absolutely mandatory. And the employee also has the right to choose which form of documentation to submit. So any of those letters from the attorneys, the court records, the medical documents, the employee can choose which of those they want to give to the employer. And on the flip side, the employer now has to retain all that information in the strictest confidence. and it prohibits any disclosure absent of written consent or request. And so this is kind of, how employers would keep medical files separate from a personnel file. The statute is kind of suggesting that employers do that as well. And so that's a lot. Illinois usually has a lot of changes to their employment laws, especially in the past few years. So I put up a couple of to-dos just to keep in mind. Like I mentioned, 2 of these statutes are already in effect. 2 become effective January 1st, 2022. So in terms of conviction records, definitely update background check policies and practices. Make sure all hiring personnel are aware of the new restrictions and all the steps they need to take, especially submitting their decision in writing to the employee and giving 5 days to respond. Also, for both VASA and the Employee Sick Leave Act, review any sick leave policies to make sure you're in compliance, any adjustments that need to be made to the leave request process or documentation required. And of course, this is very important to update all practices on when employers are seeking restrictive covenants. So make sure you're aware of those new salary thresholds, update your form agreements, because it does apply to all restrictive covenants entered into on January 1st, 2022 and thereafter. And so that was our Illinois update, and we are going to kick it over to Blake in St. Louis to cover some Missouri updates.
Sorry about that, everybody. Hi, my name is Blake Armstrong. I'm a labor and employment associate in the St. Louis office. I'm here today to provide an update on St. Louis City, St. Louis County, and I'm going to start providing the update on Missouri as a state overall, and Brian's going to continue to do so after that. I'm going to start today by providing an update on St. Louis City, which has just signed into law the Crown Act. So the Crown Act's also already in law in Kansas City. That happened in October of 2020. And it's important to know that the Crown Act is not a law in the entire state of Missouri. Right now, just St. Louis City as of June 7th, 2021. And as I mentioned previously, in Kansas City from the fall of 2020. The Crown Act is important because it prohibits race-based hair discrimination, which is the denial of employment and educational opportunities because of hair texture and protective hairstyles. Many other states have already passed the Crown Act and are continuing to discuss passing it. And as I mentioned, cities are already also doing so. The Crown Act covers protective hairstyles, including braids, locks, twists, and Bantu knots. Many cities and states throughout the United States will pass this in the very near future. Next, I want to provide an update on the MHRA. There was an important case that was decided in 2021, Sherry versus the City of Lee's Summit. This is important because it extended the leave of absence, because it said that an extended leave of absence may be a reasonable accommodation, and then an employer must provide depending on the circumstances. So this is something kind of to serve as a warning that when an employee asks for an extended leave of absence as a reasonable accommodation, the employer should look at this on a case-by-case and fact-specific basis. Depending on the specific factual circumstances, leaves of absence from work, even if repeated and extended, may nonetheless be considered reasonable, and disabilities as a legal matter may result or flow from a combination of medical conditions that, when viewed individually or in a vacuum, may not suffice alone to qualify as a disability under the MHRA. So again, the extended leave can be a reasonable accommodation, especially if it's not indefinite and if the employee follows all company policies and procedures, especially if their employee is not showing any signs of abuse. So this, again, should serve to be careful when an employee is asking for an extended leave of absence, and to really look at this on a case-by-case basis with the employee to make sure that it could not be considered a reasonable accommodation in the employee's specific circumstance. The next case we're going to talk about is another 2021 decision, this from the 8th Circuit, and it is about the reasonable time analysis for the reasonable time to investigate complaints. Title VII may hold employers directly liable for employees' actions if the company knew or should have known of the conduct, unless the employer can show it took immediate action and appropriate corrective action. So the thing that we're going to look at here is the reasonable time to conduct the investigation. In Lopez v. Whirlpool Corporation, the court held that 4 days was not a reasonable time to conduct the investigation. The reasonable time requirement to investigate and act accordingly is, again, case and fact specific. I guess you're probably noticing a theme here that when employees come to you with these issues, it's very important to look at them on a case-by-case basis to determine it. So while each case is fact-specific and few, if any, bright-line rules exist in these types of cases, one takeaway from Lopez seems clear, and it's in general employees subject to harassment by a coworker must give their employer more than 4 days to investigate a complaint about such harassment and act accordingly. In other words, Lopez appears to suggest that 4 days does not provide employers reasonable time to investigate and act on harassment complaints. Now, again, this isn't a bright-line rule, but it just goes to show that a recent decision has held that 4 days is not enough time for an employer to go through the process. The 8th Circuit has also held that 21 days was a reasonable time to investigate. So I guess that can serve as a bookmark on both ends there. One thing to be very aware of is that it's very important to act promptly regarding claims of harassment, but this case does offer some protection to employers regarding the amount of time to investigate the complaints. So the next thing we're going to talk about is the Missouri legislature's considering partial bans on non-competes. Now, we just heard about a similar ban that's already actually gone into effect in Illinois. Again, it's important to note that this has not gone into effect yet. This passed the House last session, and it moved to the Senate, and it is now referred to the Small Business and Industry Committee as of May 6, 2021. Again, this has not actually been enacted as a law yet. It's important to note that this would limit the employer's ability to give non-competes to most employees. Similar to Illinois, there's a $75,000 limit on when employers can start giving non-competes or having their employees sign non-competes. And as I'm sure you're well aware, $75,000 and under would be a vast majority of the employees. So this would limit the ability moving forward. This is a very pro-employee bill that would serve to prohibit non-competes on most of our employees. And if it is passed, it would only apply to newly entered into agreements that meet the compensation threshold. So once passed, it would be all non-compete agreements moving forward. It would not, as it stands now, retroactively apply. And again, this is proposed. Some of the laws moving forward here are proposed and not taken into effect. This is the new expungement law in Missouri. This has taken into effect. It was effective as of August 2021. It's important as it qualifies over 1,900 offenses for expungement. As you can see on the slide, only about a dozen offenses qualified for expungement previously, so a drastic increase. The key reminder here is that employers cannot ask about expunged records in the hiring process. For a little bit of context and history, the expungement law has been updated in 2016, 2018, 2019, and as I just mentioned, again in 2021. Expungement means that those offenses are sealed. Again, the employee does not have to speak about these offenses in their hiring process, and the employer cannot ask about them. That's very important to remember. And again, this is quite obviously another pro-employee law. This is one that employers need to be careful as to not make an inadvertent mistake in the hiring process. As there are over 1,900 offenses that are now able to be expunged, it's important to, I obviously can't go through them all now, but to understand those as you're going through the hiring process. And again, to make sure that there's not an inadvertent mistake when asking about these. And so this law was meant to make it easier for prospective employees to apply for jobs if they have committed certain crimes. And that is what has now happened with the 1,900 offenses for expungement. And last in Missouri is another proposed legislation. It's statewide vaccine mandates. The House Bill 838 would prohibit any public employer from requiring public employees to receive a COVID vaccine. And it would also prohibit, moving on to the next slide briefly, employers from terminating, disciplining, demoting, or otherwise discriminating against employees with respect to compensation for refusing to get the COVID vaccine. As I'm sure you've seen with the federal mandate that has come down, this would be in direct conflict with Joe Biden's federal mandate. Right now, there is no conflict because that is just proposed, but if Missouri did pass this legislation with the conflict, there would be the direct conflict with Biden's vaccine orders, and therefore, while not ripe yet, it's something to keep in mind when the legislative session resumes to see how this transpires. In summary, the federal mandate will require employees to be vaccinated. On the other hand, the state law will prohibit employers from mandating the vaccine from their employees. As we move forward, this will help the employers will need to keep both the federal mandate and the proposed legislation in Missouri in mind as they develop their own policies for company vaccine policies in the state of Missouri. And now we're going to go back to Brian in Kansas City as he continues to provide some more updates from the state of Missouri, Kansas City, and then the state of Kansas.
Thanks, Blake. What you heard earlier about was the Illinois VASA law. I'm going to be talking about the Missouri VASA law, which was recently enacted and became effective late August of this year. And so for you Missouri employers that have not heard about this, it's going to require some work on your part. Missouri has just joined a number of other states, again, in implementing this VASA law recently. So who does VASA apply to? Any public or private employer with at least 20 employees in Missouri. And what does it require generally? Two things: unpaid leave and safety accommodations if an employee or a family member or a household member of an employee is a victim of domestic abuse or sexual violence. So again, two kind of separate prongs there. If you have 20 to 49 employees, then those employees are entitled to 1 week of leave per 12-month period. And if you have 50 or more employees, those employees are allowed 2 weeks in a 12-month period. And to be clear, leave can be used intermittently or on a reduced work schedule, but you still can't go beyond that 12 weeks of FMLA. If you've exhausted that 12 weeks of FMLA, that is the max benefit that you can get. VASA comes with a few definitions. The last of these, I think, is the most important one in terms of breadth of the statute. A family or household member can be defined to include the spouse, parent, son, daughter, other person related by blood or by present or prior marriage, other person who shares a relationship through a son or daughter, and persons jointly residing in the same household. So a rather expansive definition, somewhat like what you saw with the Illinois law. Eligible employees can take leave to do a number of different things. One, seek medical attention, obtain counseling services, obtain services from a victim's organization, participate in actions to increase the safety of the victim from future violence, and to seek legal assistance. So again, these are eligible reasons under which an employee can take Missouri VASA leave. So what does the employee have to do to trigger this responsibility on the employer? First, they have to provide 48 hours of notice, sort of, unless providing such notice is not practical. I think we can all understand circumstances whereby someone would not have 48 hours of notice in a domestic violence situation. So that's built into the statute. But employees, for that reason, employees cannot take adverse action against an employee for an unscheduled absence if that employee, upon a request within a reasonable period of time, provides certification to that employer. Similarly, regardless of the 48-hour advance notice, the employer can always request certification within a reasonable period of time, and I'm sorry, it must be provided in a reasonable period of time. No one knows what that means. It's not defined, but a reasonable period. And what does this certification requirement include? One, a sworn statement of the employee, and then 3 different alternatives, including documentation, as you see here, from victim service organization, member of the clergy, attorney, employee member's household, police or court record, or other corroborating evidence. Again, that's not defined either, but kind of includes a blanket category there. So the second prong, the first prong is leave. The second prong of this law is reasonable accommodation. And so eligible employees are entitled to reasonable safety accommodations for known limitations resulting from circumstances relating to being a victim of domestic or sexual violence, or being a family or household member of a victim of domestic or sexual violence. Again, that's a quote directly from the statute. So again, reasonable safety accommodations, which we'll look at in just a second. And again, these are similar to accommodations you'll see under the ADA. I don't want to go through all these because I have just a minute left, but you can see some reasonable accommodations defined by the statute. And again, it follows the same reasonable accommodation analysis as the ADA and the same undue burden analysis as the ADA, which requires a significant difficulty or expense. And just like FMLA, upon return from leave, an employee must be returned to the same or equivalent employee position. So what are some practical tips here? One, update policies or employee handbooks to include a VASA leave policy if you haven't done so already. Train HR professionals, supervisors on VASA. And then importantly, as of October 27, 2021, employers need to notify all employees and applicants of their rights under VASA. So again, you need to make sure you have a policy and you have to distribute that policy to your employees. And again, post a notice summarizing the requirements of VASA. So again, inform your employees and post a notice. In contrast to Illinois and Missouri, our Kansas legal update is going to be very brief. There's not a lot there, and I'm out of time. The one that we'll really talk about here is that Kansas has updated its EEO notice that's put out by the Kansas Commission. It now includes LGBTQ+ per the Supreme Court's Bostock opinion. So if you are a Kansas employer and you have not posted that new poster, now is the time to do so. And then with regard to employer vaccine mandates, there's been numerous efforts to ban those in Kansas, but none of them have actually come to pass. So right now there are no prohibitions. On May 26, Governor Kelly signed a bill regarding vaccine passports and some limitations thereon. But again, that's really all that's happened in the state of Kansas. So as you may have noticed, I've moved from my presenter seat back to my moderator seat for our first poll question. And this is limited to Missouri employers only, simply because Illinois VASA law has been around for a bit. So the question is, has your organization implemented a VASA policy? Yes, no, we are currently in the process of doing so, I don't know, or we are not a Missouri employer. We're waiting on results here. Okay, so a handful have, About 1/4 of you have not, 1/4 of you are in the process, 1/4 of you don't know, and a number of you are not a Missouri employer. So again, this just goes back to in the next couple of weeks, you need to have this done and distributed to your employees. But again, we'd just like to know what our clients are working on out there and what they have in place. So thank you for answering that question. And for those of you that are not Missouri employers, we have an additional poll question about our presenter, Blake Armstrong. And I'm sure all of you know the answers here. Number one, which of the following statements is true? 1, Blake is a dual citizen with U.S. and Canadian citizenship. 2, Blake is a former hockey player. 3, both are true. Or 4, neither is true. Waiting on our responses here. Oh, everybody nailed this one, though I think it was a bit of a leading question. Personally, I would not have guessed that Blake is a former hockey player, but evidently he was. So yes, both are true in this case, and this is a verifiable answer. On a related note, I asked several of my long-term colleagues and friends if there was anything interesting about me that I could put into a poll question, and they stared at me blankly for several minutes, thinking about it. And that process in and of itself was a bit hurtful. And then they said they had nothing to offer. They had no answer. So although I can't disagree with that necessarily, it was very disappointing. I think one of our next presenters, Tyler Hibbler, suffers from the same problem. We were both referred to today by a colleague as generic. So again, disappointing, and the hits just seem to keep on coming, but nonetheless, they are what they are. So Tyler is joined by Jackie Kaufman and Kat Pearlstone. Jackie is a labor and employment attorney in our St. Louis office and is presenting from St. Louis today. Kat and Tyler are labor and employment attorneys in our Kansas City office and are presenting here with me in Kansas City today. And in this session, we will be discussing an employer's complaint response, including proper investigation techniques and virtual world considerations. With that, I pass it to Jackie, Kat, and Tyler.
Thanks, Brian. Thank you for the great introduction, by the way. Really appreciate the generic reference. Kat, Jackie, and I are going to be discussing remote investigation considerations. This is especially important now that we're sitting in a world where remote work is commonplace and will likely be commonplace even after the COVID-19 pandemic concludes. Prior to 2019, remote work was what I'll describe as kind of a trend, a growing trend within workforces. Obviously, that changed dramatically in 2020. It's now commonplace, and employers who never envisioned having remote workforces are now wholeheartedly adopting the philosophy of remote work. In terms of what that means for employers, especially in the context of investigations, that there are new and additional considerations that need to take place. And within this presentation, Jackie, Kat, and I will address those considerations. Specifically, we're going to address remote work and what involves remote work and what the heightened considerations are. In addition, we'll provide an overview of investigation topics, whether in person or remote. From there, we'll discuss intangibles associated with investigative processes, which will enable you to conduct a thorough, timely investigation. And then finally, we'll wrap up by discussing specific pitfalls and tips associated with remote investigations. So what is it about remote work that creates concerns for employers and presents difficulties when monitoring a workforce? Well, one, employee monitoring is simply different in a remote environment. In a traditional in-person workforce, monitoring employees is often done through in-person observation, discussions, dialogue, observing body movements, tone of voice, things of that nature for employees. In the remote world, that's simply not possible. Instead, employers must take a more technological approach to employee monitoring. That may be through preserving social data or internet data and electronic data for longer periods of time. It may be through establishing certain frameworks associated with Teams communications and and email communications. Or it could include updating social media policies within the workplace. Additionally, misconduct occurs in different mediums in remote work. It's not in-person traditional communication, dialogue, harassment that we see. Instead, it's communications through phones, Teams chats, text messages, emails, specifically group emails, which may include jokes or memes within them. Emojis can even constitute harassment if presented in the right and proper fashion. So these are things to consider from the employer perspective. In addition, some things that we don't normally think of. For example, if a Zoom call is taking place and an employee may have a sign or a cartoon or a poster behind them which is offensive in some way, shape, or form, that could constitute harassment within the workplace. So there's a lot of different angles that employers need to be aware of with remote work. One of these is, in addition, that it's often easier to misconstrue comments and intent with remote work. It's hard to read the lines between an email on occasion or a text message on occasion and truly understand what the sender may or may not have meant, and that can result in individuals feeling that they're being targeted or discriminated against. Finally, the line between work and personal time often becomes blurred in a remote working environment. I know personally, I've spent many days working at home throughout the course of the pandemic, and I just feel more comfortable working from my home office as opposed to the formal environment of a law office. That can sometimes blur the lines between what is appropriate and not appropriate commentary or actions in the workplace. So it's something that employees sometimes deal with differently. Regardless of these factors and the difficulties associated with remote work, liability remains unchanged for employers. You still have an obligation and a duty to make sure that your employees are not engaging in inappropriate conduct, and more importantly, you have an obligation to timely respond to any complaints of harassment or discrimination in the workplace. With that being said, I'm going to pass it over to Jackie in St. Louis.
Thank you so much, Tyler. Yes, and it's really important to understand how that misconduct can look different in the remote work setting, because there is some data suggesting that the risk for at least one form of misconduct, harassment, is increased in the remote work setting. And somewhat prophetically, in June 2016, the EEOC's Select Task Force on the Study of Harassment in the Workplace published findings online that highlighted that there is a higher potential for harassment in what they called decentralized workplaces. And what they meant by this is that management is physically separated from employees. So although this guidance was issued pre-pandemic, it applies with force to a work from home setting, because necessarily when everybody's working from home, management is separated from employees and employees generally from one another. And the EEOC's risk factors have been corroborated so far by some data that we have seen. There was a 2020 survey from Rights of Women, which is a UK women's advocacy organization. And of those who had experienced workplace harassment, 50% of them had experienced some form of harassment online. And in addition to that, very concerningly, in just the first 6 months of the pandemic, which is when this survey was conducted, 15% of those had reported an increase in online harassment in the work from home setting. So now, as a refresher, perhaps for some of you, or maybe as a crash course, for those of you who are newer to the concept of an investigation, we're going to briefly cover those basic steps and procedural fundamentals. The first step you're going to take is to review the written complaint. And if a written complaint has not yet been provided, go back to the complainant and request one from him or her. Ask them to fill in any details that they think might be relevant, including any witnesses who could potentially corroborate any of the allegations that they're making. And then the next step is to plan your investigation. And an important question that is often overlooked in this setting is who is going to conduct the interviews? Often this is a member of human resources, but in some circumstances, depending on the specific factual allegations, you might need in-house counsel, outside counsel, or even perhaps a neutral third party to be brought in as a fact finder to do those interviews. And then next, you're going to determine who you're going to interview. And obviously that list is going to include your complainant and any of your alleged bad actors. But of course, that preliminary work that you've done by reviewing the complainant's written complaint will also provide you with some information on any witnesses that might be able to corroborate some details. And next, you should consider what questions you should ask. Ideally, you will go into an interview with a skeleton outline of what it is that you want to cover and want to ask. But make sure that you're able to be flexible and adaptable depending on what direction the witness leads you in, so you can move with the flow of conversation. And then begin scheduling your interviews. So of course, you should start with a complainant, and then from there, you should move on to any corroborating witnesses that you have identified so far. And then you will end your investigation by interviewing the alleged bad actors. Then, if necessary, you can, of course, schedule up any follow-up interviews that you need to clarify information that you've received in those previous interviews. And then the next thing that you're going to do is draft the written report with recommended next steps, and we're going to talk about that next. But as a reminder, for any employee that you are interviewing that is non-exempt, if that interview takes place outside of that employee's normal working hours, make sure that they are compensated for that time. That's something that is often overlooked. All right, we're going to discuss a few more best practices here. So as you interview all of those relevant witnesses, make sure that you are requesting documentation as the interviews progress. And documentation in a technological era is necessarily going to look a little bit different. It's not just going to include a piece of paper, right? It's going to include emails, text messages, instant messages. Perhaps one of the witnesses has a screenshot from a different type of messenger app that the employees have been using to communicate. And make sure to ask for all of those different mediums when you're asking for documentation. And then something to keep in mind as you begin each interview is that you should start with open-ended questions. So a good example of this is just ask, what happened? Keep it simple. Let the witness speak and let them give their version of the narrative and see where they take you. You can, of course, ask more narrowly tailored questions to follow up if you need to. And in an internal interview, it is really common for the interviewer to have some sort of personal connection to the witness that they are interviewing. And maybe they're workplace friends and maybe they really don't like each other, but regardless of that personal connection, the interviewer needs to be really cautious to maintain neutrality and objectivity. And that includes making sure that any information that you have learned from the investigation that is confidential remains confidential. And sometimes if the investigator has a significant personal connection to the witness, it might be a good idea for them to recuse themselves and to ask a more neutral third party to step in and to conduct that interview. That way you can avoid the appearance of or the possibility of a true conflict of interest. And additionally, if the specific factual circumstances might warrant it, you can consider separation of the complainant and the alleged bad actors. Previously, separation might have looked like physically separating the parties, or perhaps scheduling them for different shifts so they wouldn't have to cross paths. But in a remote environment, separation is going to look a little bit different, and you need to consider how the parties are going to feel about specific types of remote contact. So, for example, are they comfortable being CC'd on emails to one another? Have they been invited to the same Teams meetings or Zoom meetings where they're going to be able to hear and possibly see one another? Are they able to read and react to messages in some sort of universal Slack channel? All of these are things that you need to consider. And something that is often overlooked in these circumstances is to make sure you're also considering the viewpoint and the comfort of the alleged bad actor. When one is accused of wrongdoing, especially if one is a supervisor, They may be understandably hesitant to remain in contact and to continue managing the complainant. But of course, this is a really tricky situation. And when this comes up, make sure that you consult with human resources and with legal counsel, because this is a really in-depth legal analysis that should be conducted. That separation could, under specific circumstances, be considered a form of retaliation, which of course you want to avoid. So documentation, very, very important. One of the most imperative things to keep in mind as you're conducting these investigations. Make sure that you are taking contemporaneous notes during any interviews that you conduct. So don't try to focus just on the person. Eye contact is of course important, and Kat's going to discuss that in a little bit, but you need to also be taking notes as you go and not trying to recreate those conversations and those details hours or even days later. And then as you write the final report for the employer, take care to document specific items, included a detailed log of all of the steps that you have taken in that investigation, including information on why certain decisions were made and certain steps were taken. You are going to provide in your final report some recommended next steps for the employer. And sometimes the recommendation is simply that the conduct was unsubstantiated and no further action is necessary. Sometimes on the flip side of that, the conduct will have been so egregious and substantiated that the only reasonable option is termination for the bad actor. But sometimes, even when that conduct is substantiated, it might fall into a sort of gray area where different types of discipline could be appropriate under those circumstances. So instead of termination, perhaps you're looking at a written warning, a final written warning, or even a suspension. And of course, it's going to depend on the circumstances which of those particular options might be the best option for the employer. And you should take into consideration, what have we done in the past when these types of allegations were corroborated? What is the employee's disciplinary history and misconduct history? Because those, of course, should play a factor in what you're recommending. And finally, the most important aspect of documentation, make sure that you communicate as if all of your emails are going to be presented to a jury. Keep things objective, even with those internal non-witness contacts. Avoid the urge to provide the colorful commentary that you might be tempted to provide after a particularly difficult or interesting interview. Don't be sarcastic. Remember that everything that you are saying has the possibility of being presented to a jury or a finder of fact in future litigation. And you want to consider, how are you going to come off? And very importantly, how is the company going to look when you provide any of those details? And finally, as a brief reminder, save the date. And by that, we mean make sure that you date all documentation contemporaneously as you move through your investigation in order to create a timeline that is comprehensive and is easy to follow. And next, Kat Pearlstone is going to discuss some of the more intangibles of an investigation.
Thanks, Jackie. And the first intangible that I want to go over is empathy. And I know some of you may be wondering what kind of role empathy could have in an investigation that is supposed to be objective and focused on the facts. And the answer is a big one. An internal investigation is a company's first and best line of defense against potential future liability. It's also the company's first and best chance to de-escalate a volatile situation. If you can get an employee, especially and specifically a complainant, to buy into the process, to believe that it's impartial, to have a connection with the investigator and trust that they're being heard, they're going to be much less likely to try to, relitigate it if they don't agree with the outcome, such as either going to the press or, even obtaining legal counsel. And how do you de-escalate? You empathize. And in the internal investigation, context, empathy has a very specific look. You want to acknowledge the information you're hearing when you're interviewing without necessarily validating the substance of what's being said, because that's a determination you make on the back end. And how do you show empathy, especially in a remote world where you just truly cannot replace that person-to-person contact? There are a couple of physical and verbal cues you can do. The first is, especially with the complainant, avoid interrupting whenever possible. This helps them feel like they're in control of the narrative and that they're really getting to present their side of the story. Now, an exception to that is when you really go down a rabbit hole, because while you want an investigation to be encompassing, it has to be efficient. So if you need to get a complainant back on track, you want to avoid using dismissive language like moving on or next, and instead say circling back or following up on whatever point it is you want to get them back to. So it comes off that you're actually just trying to learn more about what it is they're saying. Another thing is you want to avoid closed body language, no closed arms, no hunched over, especially when you're on the screen, that's all you can see. Jackie mentioned eye contact. When you can, you want to maintain eye contact. It's something that's really hard to do, even when someone thinks they're looking at their screen, especially people with remote work setups that have dual screens. They may be looking at the wrong one, so their eyes are more over here than at you. I wouldn't push this issue or try to direct them, but if you can, to the extent you can, maintain eye contact. And the last and most important thing, I think, is affirmative signs of active listening. And this is as simple as when you're listening to someone talk, just giving a head nod. Acknowledge that you're hearing them. It's a way to show that you're engaging in the conversation, even when you're not necessarily speaking. Again, the overall goal of all of this is to remember that an employee and a complainant, they need to feel heard to truly buy into the process. And you can help them feel heard by demonstrating empathy. So the next one is one that people are probably a little more familiar with, and that is credibility, a key component of any internal investigation. But before you can make a credibility determination, it's important to go back to the neutrality and objectivity. And you show that neutrality and objectivity by giving every single person you interview the same clean slate. And you do that with, it's the perfect word, compartmentalize. You interview the complainant, you get their story, and then you put it in a box in your head. And you interview the witnesses as you're going, and you can reference back to maybe allegations that the complainant's made you aware of, but without keeping any preconceived notions or biases from hearing their side of the story. You have to remember the alleged bad actor should get the same opportunity and the same starting point as the complainant when you're doing an investigation. So once you've maintained your clean slate, here are some key factors to look for to make credibility determinations, because whenever possible, you really want to be able to point back to tangible things to support a credibility analysis. This includes corroborating documentation, emails, Outlook calendar invites, contemporaneous notes, corroborating witnesses. This can either be someone who is an eyewitness to an incident or someone who was told about an incident contemporaneously. You can consider an individual's stake in the outcome of an investigation. This is especially true when a complainant or alleged bad actor's recollection contradicts a third party's recollection. And the last one is, notable memory discrepancies. And what I mean by that is when you're talking to someone and you're asking questions and they say, I don't know, I don't remember, I don't recall, but all of a sudden they remember a very specific conversation verbatim that happens to really benefit their side of the story. On that note, though, you want to be cautioned with the appearance of credibility. And what I mean by that is more of your instinctual response. That's when you're going to be looking at someone's body language and demeanor and saying, I don't think they're acting the way someone should act in this situation. I think that they would act differently, so I don't believe them. And you really want, to the extent you can, flag that and then put it aside, because that is not a good basis to make a credibility determination. Because realistically, being in an internal investigation stinks. It's stressful. It feels like you're getting called to the principal's office, and people handle stress differently. Some people are going to be really over talkative, some are going to come off abrasive, and some are going to shut down. And none of that has any indication of whether or not they're telling the truth. So the last intangible we're going to talk about is connections. And this really ties back into empathy, because to get someone to really buy into a process, you have to connect with them. They have to trust you as the investigator, and they have to feel like they're actually a part of the process and not just a passive participant. And how do you do this in a remote world? Easiest way is set expectations. Make them feel like they know what's going on, and so they know what to expect. Another big one is to establish rapport. And this can be as easy as just starting with some small talk. And it may sound cheesy, but even the weather, just saying if it's nice weather, or if you know something about them and a sports game has happened, just something to get the conversation started. Because these investigations are dealing with really highly sensitive subjects and emotional subjects, And jumping into that directly can be really off-putting. Even if you're dealing with a witness who maybe is abrasive or, coming off not hostile, but more defensive, another way you can establish rapport is to start with asking background information questions. Ask them about their job, duties and responsibilities, a project they're working on, just to get the flow going. Whenever you're doing an investigation, you want to be transparent whenever possible. It's kind of hard to do. Investigations are inherently confidential, but really low-hanging fruit is just keep the complainant and the alleged bad actor status updates, letting them know without giving away the substance, just, general update of where you are and when they can expect an outcome. And if that timeline change, keeps them informed, because that prevents them from feeling like they've been forgotten. And a final point is when you're doing an investigation, to avoid what I call escalating or adversarial language. And that's, when you're talking to the complainant saying, so what is the perceived discrimination, or what is it you're alleging happened? And the reason I flag this is because when you're talking to someone, you're inherently getting their perception. There's no need to flag that, and it comes off as if you are doubting what they're saying and making a preconceived notion that what they're saying didn't actually happen. So instead, as Jackie said, you want to really focus on those open-ended questions, what happened next, what was your reaction, anything else. So in addition to the intangibles, there's a couple pitfalls and best practices you need to be aware of, and Tyler is going to go over some best practices for preparing for remote interviews.
Thanks, Kat. And when conducting remote interviews, perhaps the best tool that you have in your toolbox is preparation. Preparation is the key to conducting a successful interview of a remote worker. In doing so, part of the preparation process is to be transparent and clear with the logistical expectations that you have of the individual who is being interviewed. For example, inform them ahead of time that it's your expectation that their camera will be on. Let them know that it's your expectation they will be in a private space. Keep in mind that a remote worker, typically working from home, may have individuals in their household who should not be privy to conversations and communications with the Human Resources Department during the course of an investigation. This includes things like protected health information that may be disclosed or discussed. Also, think about it from the perspective of a potential bad actor who's working at home, perhaps accused of sexual harassment in the workplace, and his or her family is in the household. So having a private space is truly critical in this situation. Inform the interviewee that it's your expectations they will not be on the phone or otherwise distracted during the course of the interview process. If there's children at home due to an issue with the pandemic, either be flexible in scheduling your interview time to ensure that they can have childcare present, or inform that they're going to need to take other steps to ensure that there's not going to be a distraction during the interview process. Also, remember that if a witness refers to a document during the course of an interview, because we're electronic, because there's remotes, we need to make sure that we ask that individual to identify the document and provide it to us in some way, shape, or form. Excellent. From the interviewer's perspective, we need to ensure that key documents are available in electronic format. Documentation is going to be shared through screen sharing or sharing of a window, so we need to make sure that's uploaded, available, and ready to go. Part of this process is also ensuring that other documentation which may be contained on your computer screen is closed. You don't want to incidentally disclose confidential information or documents during the course of an interview. Also, know how to work your software. Know how to highlight documents, point, circle on documents, and know how to appropriately configure your monitor so you don't deal with unnecessary technical interruptions. Blur your background if necessary to avoid distracting sights or visions that may be in the background, and also know how to record if necessary. And on the issue of recording, there are several considerations that do need to take place. Recording interviews in connection with a HR investigation is a hot button topic, regardless of whether or not it's in person or conducted remotely. But with a remote investigation, there are multiple additional risks and considerations that need to be evaluated. First and foremost, be aware of whether or not the software that's being utilized allows one-sided recording, whether through the interviewer or through the interviewee. Also, if you're going to make a determination regarding whether or not you want to record an interview, consider whether recording the interview will affect witness demeanor or rapport. The last thing you want to do, as Kat just hit on, is go ahead and destroy that empathy and that connection with a potential individual because you're informed that you're now going to record them and put them on the record. Also, be cautious before engaging in any sort of one-sided recording. This could carry potential legal ramifications. Missouri and Kansas are both one-party consent states. Illinois, though, is a two-party consent state. And this really raises risks in a remote environment where you may have, for example, a Kansas employer, which is a one-party consent state, but an Illinois employee who's sitting in a two-party consent state. In those situations, there's a legal analysis that needs to take place, an evaluation of the statutory framework for each state regarding who can and cannot record conversations. And that really goes down a rabbit hole that you want to avoid. And the easiest way to do it is either elect not to record, or if you are going to record, obtain that consent in advance of doing so. Go ahead, next slide.
So coming back to the intangibles, there are a couple considerations when dealing with subjective factors that are specific to a remote workforce. The first that we've already touched on is that establishing empathy and connection is more difficult in a workforce, but it's not impossible. I find what's really helpful is having an introduction prepared that really makes the witness feel comfortable. I explain who I am, my job, what I'm there for, what I'm expecting, and I even provide a roadmap of the conversation to the extent I can. Like when I'm questioning, I say, here's what I'm going to ask about first, here's part 2, here's 3. The other thing you can do in this introduction is you're setting the tone. And I will repeat this multiple times, that it is not an interrogation, it is a conversation. It's a dialogue. If you have questions, ask me. If it's a back and forth, let me know. If you have information you want to share and I haven't asked it, interrupt me and tell me it, so that they understand that they have a say and are actually a part of the process. Another thing to keep in mind is it's really hard to establish a connection when someone's distracted. So the extent you can mute your emails and put your phone away and ask them to do the same, I think that can be really beneficial. Another consideration is body language. You're not going to be able to see some physical signs of nervousness that you normally would, like maybe foot tapping or just fidgeting in general. Not to be used for credibility determinations, but that information can be helpful for determining a witness's emotional state. And so if you need to adapt your investigatory techniques. And so you need to be aware that you're going to be more focused on their tone rather than physical signs of discomfort. The last thing that may come up is a witness may take advantage of a remote work environment and, all of a sudden lose connection or turn their video off when you're getting to the tough stuff. If that happens, do not get accusatory. Get them back on. If you need to reset. But the most important thing is to write down the question you were asking, because the whole goal when that happens is to get you to forget the question and not do the follow-up. And that's the most important part, is just to make sure you pick up right where you left off and get that question answered so you're not missing key information. So in addition to these subjective considerations, you really need to be timely in your information, right, Tyler?
Absolutely. One of the key takeaways from today's presentation should be that it's critically important that investigations are performed in a timely manner. And this is not only important from a workforce management perspective and keeping people advised of the status of an investigation, but from my perspective as an attorney who may represent you down the line if you are in trouble, it's critically important in my ability to defend you. Specifically, there are available affirmative defenses that we can assert on your behalf if you're in litigation, which are dependent upon conducting a reasonable and efficient investigation. The Farragher-Eller affirmative defense has been around since 1998. That's a combination of 2 United States Supreme Court cases, and it's commonly asserted as an affirmative defense within federal cases. An example of how this can go off the rails is a recent Sixth Circuit case where a manager received a report from an employee, and it took 9 days for that manager to report that complaint to HR. HR then delayed 13 additional days prior to reaching out to the employee who made the initial complaint. And it took an additional 6 days for HR to then separate the complainant from the alleged bad actor. Initially, this case was litigated, and the employer asserted an affirmative defense based upon the fact that, hey, we investigated, we did it appropriately in our investigation, and our response corrected the situation. They won summary judgment, but it went up on appeal, and the Sixth Circuit issued its ruling indicating that a 3-week delay, 21 day in investigating an explicit and specific complaint suffices to defeat summary judgment. So now the employer was defeated on summary judgment and sent back to the situation where they're going to have to go to trial to defend the case. The flip side of that coin is a recent case out of the state of Missouri. Missouri also has a state case law which supports an affirmative defense based upon an appropriate and timely response to a complaint. In the Six Flags case, this was a situation where there was not delay. An employee made a complaint. The next day, the supervisor went to HR. HR began its investigation the same day and immediately suspended both bad actors. The bad actors were then terminated the following day. And HR even contacted the police about one of the incidents of misconduct. There, Missouri Court of Appeals said the employer acted appropriately, timely, and engaged in appropriate remedial action. All good things and things that should be considered in any investigation.
So a couple last pitfalls. One that might come up is press threats, either that they've already gone to the press or that they may go to the press. And the number one thing to keep in mind when this comes up in an investigation is to de-escalate. That's always an underlying goal. And really what I mean by that is when someone makes a threat, a really common natural reaction is almost to want to rise to their level and maybe make a threat back or tell them you can't do this or even consider disciplinary action. And I really encourage you just to stifle all of that and instead take a deep breath, remain calm, and try to redirect back to the internal investigation. You know, that's the goal. They have a right to go to the press if that's something they want to do to raise their concern. What you can do is go back to your intangibles and get them to buy into this process and believe that this is the best option for them. And when I've dealt with press threats, I acknowledge, I say, that's something you have the right to do. I can't advise you on that, but I think that this is the best avenue, and I'd really like to continue our conversation and go back to working on rapport and getting them back in the conversation. The other thing to keep in mind, if you are aware that press is contacted or that there's been a threat of press, you're going to want to coordinate with the applicable departments, which is definitely going to include legal counsel and public relations. These may be in-house teams or a third party that you retain to assist with a specific incident. One of the last pitfalls I want to really briefly touch on is protected concerted activity. And just a very general overview, this is a protection that's provided under federal law to all employees, regardless of whether they're union or non-union. And basically what this protection allows is for employees to discuss concerns related to the terms and conditions of their employment that affect more than one employee. So it's not personal grievances, it's something that affects more than one employee. And they can have these conversations without threat of discipline or repercussion. The definition is really expansive, and the caution and the reason I wanted to flag this is if there's a situation where you have a complainant who is in the middle of an internal investigation and still talking about their complaint, and it's maybe causing discord in the workplace, you want to be careful about issuing discipline because you may be falling into protected concerted activity. So if that issue arises, I strongly recommend that you contact legal counsel. We focused a lot on what to do once a complaint's been filed, but there are also a lot of proactive steps you can take on the front end. We've kind of listed out a few here. You want to regularly review key policies. A lot of these are going to look familiar to you guys: anti-discrimination, grievance reporting. Social media is a hot topic right now. One that's specific to remote work is data retention, because there's going to be a lot more electronically stored information when you're in the remote workforce. Consider training, whether it's management training on digital harassment or an employee refresher on how the complaint process works, because they're not going to be able to walk into HR anymore. There needs to be a really clear path of who they can contact when they have a concern. And you may want to consider establishing an anonymous hotline. And I know we've covered a lot, so we went ahead and condensed this. So if you're only going to print out one slide, this is the slide to take. And these are just kind of the key takeaways of things that we really want to make sure that you remember. The first is preparation is the key to a successful remote investigation.
Absolutely. And be sure that you document your investigation as if you're going to present it to a jury.
And I just can't harp on this enough. Establishing a connection with a witness in a remote interview, it can be hard. It's going to take more effort, but it's absolutely possible and it's worth the payoff.
And make sure you're conducting those investigations in a timely manner. Not only is it beneficial from your workforce management, but it'll help your attorney if you're ever in the situation where you're being engaged in litigation.
Absolutely. And most importantly, repetition is key here. Maintain objectivity and neutrality.
Absolutely. And that's our time. We really appreciate your attention today. If you have any questions, feel free to put those into the Q&A. We'll respond to them the best we can. With that, I'll pass it back to Brian.
Thanks, Kat and Tyler. A lot of good information there. Thank you both. And in the spirit of conserving time, I'm just going to move on to our next poll question. As to a report of alleged employee misconduct at my organization, Option 1, I've responded to a complaint or conducted an investigation. Option 2, I have participated in a response to a complaint or an investigation. Or 3, I have not responded to or participated in a response to a complaint and or conducted or participated in an investigation. And again, we're just trying to gauge our audience here to see what you guys are experiencing on a day-to-day basis. Wow. Okay. So about 80% of you, it appears, have conducted or participated in an investigation. So hopefully you found the content helpful in that last presentation. The next poll question, kind of a follow-up here. Working in a remote environment has impacted my organization's ability to investigate HR complaints. Agree, disagree, or I don't know. Okay, it looks like, well, kind of across the board here, it looks like a majority of folks do not think the remote environment has impacted their organization's ability to investigate HR complaints, which is a good thing. For those of you that agree or don't know, or even if you disagree, hopefully, again, some of these tips and strategies presented in the last session were helpful to you. And one more poll question that I think is critical here, and that is Kat Pearlstone. Kat actually loves cats. True or false? By the way, Kat's still in here smiling. I don't think she knew I was going to ask that question. Well, those of you that said true are right. This is what I call irony. But yes, Kat is in fact a heartfelt lover of cats. So anyway, very critical polling question there. Last up today, we have Randy Thompson, Danielle Reed, and Jenna Brovsky. Randy and Danielle are labor and employment attorneys practicing in St. Louis and are joining us from St. Louis. Jenna is a labor and employment attorney who practices in Kansas City and is here with me in the Kansas City office. They're going to discuss the very timely issue of vaccine mandates, and I expect that a lot of you are dealing with these on a day-to-day basis. So Randy, Danielle, and Jenna, over to you.
Thank you, Brian. As he mentioned, Randy and I are going to start off with a brief overview of the law as it currently stands today, which is always subject to change. And then we're going to address some of the recent state orders, legislation, and proposed legislation in Illinois and Missouri regarding COVID vaccine mandates. We'll also discuss conscience laws and the potential application for employees who refuse to get vaccinated on moral or religious grounds. We'll also discuss the impact of unemployment benefits, and then we'll hand it over to Jenna in Kansas City to discuss the recent federal executive order regarding COVID vaccine mandates for federal contractors. So as a refresher, currently neither private nor public employers are prohibited from implementing COVID-19 vaccine mandates for employees, either at the federal level or at the state level in Illinois, Missouri, or Kansas. Of course, it's important to note that employers must make reasonable accommodations or exemptions from a vaccine mandate for employees who have medical conditions or sincerely held religious beliefs that may prevent them from receiving the COVID-19 vaccine. But employers are not prohibited from implementing such a policy. It's also important to note that there are certain employers and employees that are subject to laws requiring COVID-19 vaccine mandates. At the state level, as relevant here, Illinois currently requires it for healthcare workers, school personnel, higher education personnel, and students, and employees, contractors, and vendors of state-owned or operated congregate facilities. There are also federal mandates that require it for certain employees, and Jenna will discuss that in more detail. So in Illinois, by a recent executive order, the governor issued COVID Executive Order 87, which mandates the COVID-19 vaccine for healthcare workers, school personnel, higher education personnel, and higher education students. So this mandate actually applies specifically to the workers rather than the employers. But for, say, the healthcare facilities or the education facilities, they are required to keep employees or workers who are not vaccinated out of the facilities until they receive the COVID-19 vaccine. The only exceptions in the mandate are for ADA and Title VII, sincerely held religious beliefs and medical conditions that prevent individuals from receiving the vaccine. So for employees, including healthcare workers, school personnel, and higher education personnel that are subject to this mandate, they were required to receive the vaccine by September 19th. And then within 30 days, they were supposed to be fully vaccinated. I'm not sure exactly how the timing works on that, but hopefully by now, they've all received the second shot and should be fully vaccinated within the next couple of weeks. So the executive order also mandates the COVID-19 vaccine for state employees, contractors, and vendors who work at state-owned or operated congregate facilities. And some examples of these facilities include prisons, juvenile detention facilities, veterans' homes, and other facilities for mentally disabled individuals. But there's quite a few other facilities, but if they're owned or operated by the state in Illinois, they are subject to the mandate as well. So contractors and vendors are not subject to the mandate if they're only present there for a short period of time and their interactions with people are fleeting. This is supposed to be determined by the individual facilities. And some examples of this is maybe if a contractor is just making deliveries and they're not coming into contact with individuals or staying in contact with them for long. But again, that is to be determined by the individual facilities as to whether a contractor or vendor is required to be vaccinated to come into the facility. And for those workers, they were required to get the first dose of the COVID-19 vaccine by October 14th, and then the second dose by November 18th.
All right. Thank you, Danielle. Good morning or afternoon, as the case may be, to everybody. Good to talk to you all. Miss seeing you all in person, but good talking to you anyway. I want to segue for 1 second here because I've been sitting in the green room before this thing started for about the last hour and 20 minutes. And of course, you know, my attention span won't let me get too far on this. I don't know if you all, some of you are too young to remember this, but when I was young, I'd go to the dentist's office or I'd go to the doctor and they had these highlights magazines. And one of the coolest things in there was they had where they'd show two different pictures and you had to show the differences that were in the pictures. And it would be like, show me at least 5 differences in there. And I couldn't help but thinking about that as we went back and forth between these two offices in our 2 nice studios there. Aren't they beautiful? But they're pretty close. We were talking a little bit about which one looks a little bit nicer than the other. And all my mind could do was to start going through and figuring out the differences in this. I don't think we have a prize today, unfortunately, for it, but I can guarantee you from sitting there, there are at least 5 differences. I'm going to give you one tip as we go ahead. A little horse back here. There's a freebie for you. That's the free space bingo for everybody. So, sorry, I'm sure there was somebody else out there that was thinking the exact same thing as me, and I just want you to know you're not alone. There's more than one of you out there. So I'm going to talk for a few minutes about the Missouri legislation. I know Blake covered a little bit of this before, but I wanted to recap it just in case some of you may not have been able to participate at the beginning of this. There's not much. There was a little bit more in Illinois going on, not as much in Missouri. The proposals 838 and 566 have not passed yet. 838 would prevent, go ahead and hit the slide. Yeah, that's okay. Would prohibit public employers from requiring the COVID vaccine or political subdivisions for adopting mandates for public employees. So this was kind of just the not covering all employers, but trying to cover the public employees, public employers and public employees. But as you see, that hasn't moved since April. And we've seen some other states like, Texas and Florida get a little bit more aggressive. That so far hasn't happened in Missouri. And then also in 566 was a little bit more of an aggressive one. And that would prohibit the public or a private employer from requiring employees. And you see a list here where face coverings, undergo testing for disease, do contact tracing, or receive an immunization against a contagious illness, which is a fancy way of saying they don't have to get the COVID mandate on this. But that hasn't passed either, and that's still pending. We don't know where that's going to end up. And I think this is interesting, and this kind of just shows you Missouri politics at its best, and I apologize for any Missouri politicians that are in our audience, which I doubt. But I think it's funny that they specifically put in here, and this is part of the process of trying to get these through. Employers, you can still request employees to do all of these things, but if the employee says, no, you can't do anything about it, which of course we all know really is nothing to offer that. But I always find it interesting when they put that in there. Now, House Bill 271 has passed, and this basically is a vaccine passport law. And what it does is prevent any county, city, town, or village receiving public funds from requiring the vaccine, requiring proof of the vaccine, which is commonly referred to as the vaccine passports. And this prohibits them from doing this in the setting of transportation services or public accommodation. And so what you might see, what I've seen a lot out there is, for example, in the airline industry, or if you see concert venues, things of that nature, you see a lot of that in the news now where some of the private concert venues are requiring proof of vaccine to enter, or at a sporting event, things of that nature. And that's what this is designed to do. But it's only limited to those receiving public funds from the county, city, town, or village.
So now we're going to switch gears a little bit and talk about conscience clauses. So this is kind of a recent issue that has come up, and the question is really whether an employee who does not want to get the COVID-19 vaccine for reasons that maybe don't amount to a sincerely held religious belief can rely on their state's conscience clause to object to it and be protected from being discharged or leaving their employment due to their refusal to obtain the vaccine. So these laws generally protect healthcare providers and employees who refuse to provide or to provide certain healthcare services on either moral or religious grounds. Most states have a statute, a conscience law, and historically these statutes were aimed at protecting providers who did not want to perform abortions based on a moral objection to doing so. And so these statutes prohibit discrimination against employees, nurses, doctors, and other healthcare providers who choose to exercise their right of conscience in order to not perform an abortion or some other medical procedure that they have an objection to. So these protections vary widely by state, and Illinois actually has one of the broadest statutes in the country. And so their conscience law applies to all employees and employers. It's not limited to the healthcare context, and it applies to any healthcare service. So a lot of statutes, state statutes, will limit it to just certain healthcare services, such as abortion, sterilization, contraception, which is what both Missouri and Kansas do. So those laws are much more limited, and they're also limited to just the healthcare context to healthcare providers. So based on those limitations, it's extremely unlikely that any workers in Missouri or Kansas would be able to trigger this law or protection against being discharged based on their refusal to either give a COVID vaccine, receive a COVID vaccine, or anything along those lines. But since Illinois statute is so broad, there is a chance that it could be used in this context, and people are already making those arguments. So Illinois' law prohibits both public and private employers, both in the healthcare setting and outside the healthcare setting, from discriminating against individuals who refuse to receive, obtain, accept, perform, assist, counsel, suggest, recommend, refer, or participate in any healthcare service that is contrary to their conscience. So it's not just providing those services, it also includes receiving those services, which is why it could be applied in this context. The language is extremely broad. So an employee who refuses to receive the COVID-19 vaccine or even a COVID-19 test may be able to, or may be protected against discrimination by their employer for refusing to do so. It could also potentially protect an employee who objects or refuses to require other employees to receive the COVID-19 vaccine or take a test. So if it's an employee's role, in human resources or some other position that they have to implement or enforce a COVID-19 vaccine mandate, they could potentially be protected under Illinois' conscience law. And so Illinois defines a conscience as a sincerely held set of moral convictions arising from a belief in relation to God, or which through not so derived arises from a place in the life of its possessor that is parallel to that filled by God among adherents to religious faiths. So this is very similar to a religious belief that could potentially cause an employee to be exempt from a COVID-19 vaccine mandate, but it is broader than a religious objection under Title VII or the state statute. And it's easier for employees to trigger those protections. So even if they don't have what you typically think of as a sincerely held religious belief, they may still be protected under Illinois' conscience law. And it's also noteworthy that there's no defense for undue hardship. So an employer, even if they don't want to provide the accommodation or the exemption because of a moral belief that the employee has, they won't be protected if doing so would cause an undue hardship on the employer. So this is potentially very far-reaching and really impacts Illinois employers.
Okay. I'm going to talk for a few minutes just about unemployment benefits. We're going to cover Illinois, Missouri, and Kansas, but really the results have been kind of the same and the analysis is the same on these. So I want to briefly just kind of cover the way this works, and then we'll get into a little bit more of it. And again, we're not seeing a lot of results on this yet, but we've got a little bit of recommendation and advice for you on this. So typically in all three, we've got the statutes on the side there for you for each state, but essentially they're identical in terms of what they are. So individuals are generally not eligible for unemployment benefits when their employment ends if they've either voluntarily quit without good cause or they're discharged for misconduct connected to the work. So generally falls into those two. And so what does that mean? So if they involuntarily quit without good cause, it would have to be circumstances such that a reasonable person would be justified in giving up an employment. So historically, in kind of the employment context, it's like a constructive discharge. The working conditions were such that the employee felt no other choice but to terminate the employment. Now, in those cases, the burden's on the employee to prove that. And the difference here on the other prong of it, where it's misconduct connected to work, is the burden's on the employer. So you have to show that the employer, involuntarily fired the employee due to misconduct. And you see a couple of examples up there. So where does this fall in terms of unemployment benefits with the COVID vaccine? If somebody is let go, is it considered a resignation? Is it considered good cause and misconduct as an involuntary termination? Is it attributable to the employer because it's due to a COVID vaccine mandate that the employer has implemented? I mean, that's what we're wrestling with on all these cases. Now, what we have seen to date is almost nothing out there. And in fact, I'm not surprised because these take a lot of time to get through the process and to be recognized out there. Typically, these are administrative decisions and they will go through the administrative process, and most are not appealed. So whether there's finding for or denying benefits, they don't get appealed. But once in a while, they go up through the court system, and then that's where we see decisions on this. Now, you all out there anecdotally might have more recent information than we do. Certainly encourage anyone, if you have experiences at your companies, let us know what you're seeing out there on these. Now, most states have taken the position that eligibility for unemployment benefits will be determined case by case. So technically, these all have to be individualized. So you can't just put them into one bucket and say, well, it's due to the COVID mandate. But the consensus is, and what we found out there is that generally speaking, the employees are not eligible for unemployment benefits due to termination of employment for refusal to get the COVID vaccine. Now, keep in mind, as we've got up there on the slide, there's still some exceptions out there. We've talked for many months now, if not longer, about the exemptions for religious or medical reasons that may apply to an individual who does not want to get the COVID vaccine. And those we expect could still apply if somebody is terminated who presented a valid exemption request and that's denied and they seek unemployment benefits. And we don't know what other reasons there might be out there. Also, one issue that I think is unexplored and we just don't know the answer to is how this may conflict with the federal mandates that we're seeing now and how that's going to shake out, because we may have employers out there that are going to be subject to federal mandates, and then how is that going to play out with the unemployment? We just don't know yet. One thing I will add is, I don't think this is going to have any significant impact on any different or related employment litigation that may come out there. One of the questions I get sometimes is on a finding of unemployment or non-employment, how does that impact a potential claim that we might get from the employee later on if the employee brings a lawsuit or files a charge of discrimination for some type of unlawful conduct? Does a finding that the employee was eligible for unemployment benefits adversely affect the employer's defense? Typically, I would say no, and I haven't seen any situation where that does. The standards are so different and the settings are so different that I don't anticipate that that's going to have any meaningful impact on those situations. So I think right now we're going to throw it back over to Kansas City, to Jenna, to talk about the federal executive action.
All right. Thank you, Randy and Danielle. If you're playing along with Randy's Spot the Differences, I'll give you another one. We have a little bird here as opposed to a little horse. And with that out of the way, let's get started. So I'm going to talk about federal executive action. So really, since the President Biden came to office, he's been talking about vaccines. And last month, on September 9th, he rolled out the plan to stop the Delta variant and boost COVID-19 vaccinations. There's a lot of pieces to that, but what we're going to focus on today is the 3 sets of workers that are impacted by President Biden's plan. The first are federal employees, and that was pursuant to Executive Order 14043. Now, I don't anticipate a ton of federal agencies on today's call, so we're not going to spend a ton of time there. We're going to focus mostly on the second set of workers, and those are federal contractors, and they're affected pursuant to Executive Order 14042. The third set of workers who will be impacted are private employees, and we are waiting with bated breath for the federal government, for OSHA and for CMS to each respectively issue guidance. For OSHA, it will be an emergency temporary standard. For CMS, it will be an interim final rule that will relate to private employees. And just my luck, I bet they're announcing it right now. But don't leave quite yet. We still have some exciting things to say. So wait till I'm done, and then you can start furiously Googling. But as of 10 minutes ago, no announcements have been made. All right. So what are we dealing with for federal contractors? So we have an executive order. And then on September 24th, about 2 weeks later, we got some guidance from the Safer Federal Workforce Task Force. You can try saying that 3 times fast. I will not. And what does that exactly do? Well, it puts the onus, first and foremost, on the federal agencies to include in their contracts and contract-like instruments certain safety protocols. What's a contract-like instrument? I could certainly nerd out about that, but again, I will not. Basically, it's an agreement with the government that's legally enforceable. Now, there are certain cutouts, so it's definitely worth checking that out or calling your friendly attorney for more information, but there's a threshold value for contracts. The order does not apply to grants. It doesn't apply to work outside of the United States. So make sure that you check that out before you dive too deep. So what is the big requirement here? The big requirement is COVID-19 vaccination of your employees, hard stop. Testing is not an alternative other than perhaps as an accommodation for those groups of employees who are legally entitled to request it. So I'm going to repeat that because there's been a lot of kind of misinformation. In terms of the federal contractor requirements, COVID-19 vaccination is the requirement. Testing is not an alternative. Now, employers do not have to provide or administer the vaccine, but they do have to let employees know where they can go get the vaccine. And in addition to vaccination, we have those true blue safety protocols that we've all been living with for the past year and a half. We have required masking and social distancing, and we even have a requirement to designate a workplace safety coordinator to implement it, which is probably a good thing to do anyway. Now, I mentioned accommodations. What are we talking about? There are 2 groups of employees, those with disabilities and those with sincerely held religious beliefs against the COVID-19 vaccine. And so I'm going to reiterate, it's sincerely held religious beliefs against the COVID-19 vaccine specifically because we've been asked a ton of questions. And so if you find yourself with employees who are requesting accommodations on one of those 2 bases, it's the same analysis, the same standard that you use for any workplace accommodations. Is there a reasonable accommodation that would not pose an undue hardship on the employer or would not pose a direct threat on the employee or others in the workplace? And perhaps testing falls within that. It's a very fact-specific inquiry. And the last requirement or note is just that if you're working on federal property, there might be additional requirements outside of what's specific to the executive order. All right. So let's jump into when does this go into effect. It's a little bit confusing. So November 14th is the date by which any new contracts awarded must include these additional safety protocols, the vaccination, the masking, the social distancing. But federal agencies have been encouraged to include it sooner, and in fact, that's what we're seeing. Additionally, any contracts that are currently in place, this executive order would not apply to unless and until they're extended or renewed. So when you get to that moment of change, extensions, renewals, options, that kind of bilateral change, that's when we're going to see this kick in. And December 8th is the drop dead date for those who we know are covered, or if there's a new contract, it's going to be the first day of the period of performance on a newly awarded contract. So again, there is intended to be a little bit of phase-in time, but we're already at October 19th, so we're kind of already seeing this being included in contracts with the federal government. So who is covered? This is extremely, extremely broad. It's those who are working, quote, on or in connection with a covered contract. And that includes the person who's physically building the facility, and it includes the person who's sitting at the office doing their billing. It includes human resources. The guidance that came out from the task force is extremely broad, and it expressly states that remote employees as well, if they're working on or in connection with a covered contract, need to be vaccinated and adhere to the same safety protocols. Additionally, if you have some workers who are working on a contract and some workers who are not, but they share the same floor, the same space, the same area, that space is going to be designated as a covered contractor workplace. And as such, those folks are also going to have to be covered. So it's really broad. Practically speaking, to think about, if you have some employees who technically fall within the executive order and you have some employees who don't think about staffing, is this going to preclude, switching people from one contract, one project to the next? Is it going to cause internal strife if you have some folks that have to be vaccinated and other folks who don't? So there's a lot of practical implications when we're talking about COVID protocols. So the last topic I'm going to touch on briefly relates to non-employees, other people in the workplace, including visitors. So Randy and Danielle talks somewhat about this, but generally, you can mandate COVID-19 safety protocols for people who are coming to your workspace, and that includes vaccination in Missouri, Kansas, and Illinois, but subject to, first, public accommodations. So we're talking about employees requesting accommodations based on sincerely held religious beliefs and disabilities. That same framework exists for places of public accommodation. You own a theater, you own a restaurant. There's the same type of requirement to accommodate people who fall into one of those two groups. So we want to be mindful of public accommodation laws. We also want to be mindful of any city-specific ordinances that somehow limit COVID-19 safety protocols. And as I said, a lot of this is practical. So when we're thinking about what are we going to require of folks who are not our own employees coming into the workplace, here's a few things that are at the top of my list. First are business concerns. What will customers think? Are we going to lose business? Or maybe they actually want this too, right? Maybe they'll feel more comfortable using us or coming in to meet with their law firm if folks are vaccinated. So the people who are buying your goods, who are your clients, that's something to think about. The second consideration is employee morale. How will your employees feel if, even though this requirement is coming down from the federal government, you're implementing it, and other folks don't have to abide by it, like contractors or visitors? And the third is just general safety. Query the efficacy of a policy you're requiring vaccination if everybody isn't actually vaccinated. So as you craft your own policy and navigate all this, we encourage you to reach out to us and consider that new guidance is coming out, momentarily in October. So we're certainly here to help. And with that, I'm going to pass it back to Brian. Thanks so much.
Thanks, Jenna. Good information. I have some good news to share. It looks like we're running a few minutes early, which I think everybody appreciates. Candidly, we expected Randy to go much longer than he did. I think, as you can see, he's a bit of a talker, and yet he kind of kept it slim there. So nonetheless, we have one more poll question and a couple of closing remarks, and we'll get you out of here. So the last poll question, based on what you just learned in our presentation, does your organization have employees that are covered by the federal contractor executive order on COVID-19? Yes, no, or I don't know. Okay, so it looks like primarily no, 51% no, 32% yes, and 16% I don't know. For those I don't knows, I certainly encourage you to reach out to Jenna, and she can help you figure out the answer to that. So overall, thank you for joining us today. We certainly hope that this information was helpful. We know that some of you still have questions out there pending. Again, we've had people answering them. There's been dozens and dozens of them. So if we have not gotten back to you thus far, I will get back to you after the presentation. Again, this program has been approved for HR and CLE credit. To report your hours, again, click on the CEU icon at the bottom of the screen. A certificate of attendance, including the course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. And please be sure to complete our short survey. Again, your feedback is critical for us to plan future programs and make sure that we are giving you what you want. This concludes our program, and thank you very much for your time and attention.